Item 1.
Yeah. Hello. Thank you for I learned so much from you. Yesterday you argued so well. Yes.
Item 2.
Yeah.
Please, Your Lordship.
Yes.
We are this society.
Any urgency?
There's an interim notification which was published by the BDA that the comprehensive development plan of Bhubaneswar that would include the lands which belong to us in the agricultural zone. We have given our objection.
Next.
Item 3.
Yeah. 3.
Item 3.
Yes.
Sir, may I please it, Lord? So this is a matter in which...
You can address me as sir. That's sufficient.
Sir.
You're not lords. Only one lord above.
Sir.
Yes.
So this is a matter in which adverse remarks have been incorrectly issued against me.
What are you doing, sir?
I'm a lecturer in English at BJP Autonomous College.
English lecturer.
Lecturer.
In which college?
BJP Autonomous College.
For a moment, can you tell me who bitterly criticized the English language, an Englishman? How will you teach your students? English language was bitterly criticized by an Englishman. As a lecturer in English, you have to know that.
George Bernard Shaw.
You are right. Yes.
Sir, this adverse remark was issued for my par of for the year 17-18. The par for the assessment year 17-18. But that was issued to me belatedly after 5 years. Means the adverse remarks was communicated belatedly after 5 years.
After 5 years.
And also, the adverse remark has been issued against the rules of the G and PG department, which is the nodal department.
This is not the department which issued.
This is the administrative department. It has to follow the rules issued by
notice.
G and
We'll
PG
ask them and then let them file objections. Hello?
Whether there is a IA for interim relief.
What interim relief, sir?
In this IA, I am praying that there may be a direction for convening a review DPC and promoting me subject to the result of this petition.
That will be true. Generally, such orders are not there. Let us see.
The latches are from government side.
Let us issue emergent notice. Mr. G is requested, Mr. Lenka, learned DG is requested to accept notice for one OP?
One office.
One notice for first one. Call in the 3rd week of December, since there is some arguable urgency in the matter.
So what a fixed date did it on the one fixed
Date I cannot fix. 3rd week of December.
Okay.
Next.
Item 4.
Item 4, my lord. The petitioner is a PET. He is claiming IAC-PET still. Similar benefit has also been extended under Annexure 8.
The matters we have decided.
Yes, yes.
Do you have any order?
Yes.
Yes. Have you changed? Not changed?
No, not required by you.
Not required. Identical.
Only no.
Annexure 10 is the representative one.
Except the subject matter of this petition is substantially similar to the one in WP number 29214 of 2025 between Aparna Patra versus State and others, decided by this court wide order dated 27/10/2025, wherein a direction has been given to consider the representation of the litigant of the kind in a time-bound way. First time. Learned AG Mr. Lenka, on request appearing for the OPs, does not much dispute this position. And after all, the prayer is for passing an order, to pass an order on the representation of the petitioner
Annexure 10.
Dated the 13/4/2024, a copy whereof avails at Annexure 10. First one, representations of citizens cannot be kept in a limbo indefinitely. Since there is a mandate enacted in Article 350 of the Constitution of India, as has been extensively interpreted by various high courts in the country, as rightly submitted by the Learned Counsel appearing for the petitioner. First, next time, in the above circumstances, petition is disposed of, directing 8 weeks. Solicit, no courts. Now, no courts, okay? Just looking.
Well, other matters are similar, ma'am.
These matters are similar.
Yes, ma'am.
Wait.
Item 5.
Same matter. Yes, sir.
Ma'am, let's item 6.
6.
6 to 5. Sorry, Lordship. Extreme sorry, Lordship. 5. Lordship, straight let's see, before coming to the facts of this Lordship, can you come to Annexure 1, Lordship? In fact, this writ application is still pending. With operation of this order, my senior friend is appearing in that case, Lordship. Lordship, can you come to case 17?
Let him serve a copy.
Yeah, I will serve, but the urgency there, Lordship. Otherwise, I will serve a copy, definitely. Lordship, page 17, Lordship, in interim application, as an interim directed, the status quo as on date over the case land shall be maintained by opposite parties such as this period, Lordship. That is case is still pending, but unfortunately on the date, Lordship, that fixed, the matter was not on the board, Lordship, but it's still pending. But Lordship, straight come to page 20.
20.
20, Lordship. Now they have come up, Lordship, to dispose us, Lordship. Lordship, can you see their payer, Lordship? The applicant company must humbly pay that Hon'Ble Court may please to issue notice to the opposite partner to take back the seized inventory materials on payment of the damages amounting to rupees 1.53 crore and cost of eviction amounted to rupees 1 lakh in pursuant to section 7 of the PP Act 1971, which after published the notice in at
This
least...
is your representation.
Lordship. No, Lordship, their Lordship.
Your representation.
Lordship.
But serve a copy on the learned senior. You should know what is your case now.
Lordship.
We'll call this on next sitting day.
Next reading, Lordship.
Give copy.
Lordship, only pray. Till then, Lordship, no. Lordship.
No. We have already taken possession.
Lordship, kindly see.
9.
Lordship, kindly see that conduct. That is your... That...
The interim order was passed in the earlier petition for a particular date. Thereafter, it was not extended. And the against an order.
Anyway, now you are the issue notice. Who are these
Case 9.
What's your case?
Mr. Lenka requested to accept notice for voting number 4. State is a party.
Lordship.
Yes.
OP4 is
Four party, Lordship.
Generally, state is made the first part.
First part,
If
Lordship.
union is there, union is made the first part.
Sorry, Lordship, that is wrong language.
Anyway, all right. Four. The learned panel counsel, Sri Saintsai, requested to accept the accepts notice for OP numbers 1, 2, and 3. First, call this matter on the next sitting day of the quorum, since urgency is pleaded.
It's on the same heading, Lordship.
Then Monday. Yeah.
May I please get 6?
Yeah.
In this case, my lord, so day before yesterday, my lord, one similar matter your lordship had, my lord.
Similar matters were issued notice.
Is notice, my lord.
Attachment of order dated 16,
My lord.
25. What is that order, sister?
My lord, so in this case, my lord, the petitioner was, my lord, put under suspension without any show cause.
Issue about that.
An appeal has been rejected on the ground of delay, madam. So what I suggest to Lordship, Lordship can remand the matter to the apparatus.
Then I will condone the delay and remand.
Yes.
Again, he will reject.
No,
I condone the delay.
yes, your Lordship. That is apparently there no opportunity.
My lord, your lordship should interfere, my lord.
Agreed.
My lord, hurry. Smile.
He is agreeable with you. Still you want to watch him?
My lord, telling that again I have to go Bhubaneswar for fast.
Naturally. Because it is a tribunal,
My lord.
statutory tribunal.
My lord.
It knows how the work to, because it has advantage of accumulated wisdom sitting on the seat, which I do not have. So what I will do is, as he rightly said, we will condone the delay. Let him take the decision on merits in a time-bound way. I keep open all contention.
My lord.
But that has to be done. You are the only OP.
Yes.
So, the short grievance of the petitioner is against the Odisha Education Tribunal's order dated 16/8/2025, whereby appeal has been negative only on the ground of delay, without giving an opportunity of hearing, without giving due opportunity of hearing. First, the senior advocate appearing for the petitioner submits that ordinarily in matters like this, the delay has to be viewed leniently, tribunal being the special statutory body constituted under the provisions of Orissa Education Act 1969. Right. First off, she further submits that this approach not being reflected, matter is required to be remitted for consideration on merits, after condoning the delay. First, with this proposal, learned AGA Mr. Lenka, although initially opposed, is now agreeable graciously. First, next one, in the above circumstances, petition having been favored, the impugned order is set at naught, and matter is remitted to the tribunal after condoning delay. First, as a consequence, the tribunal shall decide the matter on merits. First, all contentions of the parties are kept open.
Well, this is opposite part number 4, the appellate authority, my lord.
Appellate authority, not tribunal.
No tribal.
Then instead of appellate authority, you should say instead of tribunal. Wherever tribunal is there, say appellate authority. Okay. Within what period you will dispose of that appeal? Again, coming here for one more round of litigation.
2 months, Your Lordship.
Appeal to be disposed of within an outer limit of 3 months.
Oh, yes. My lord, another matter, my lord, is not uploaded.
Not yet uploaded.
Not yet uploaded, my lord, that WPS number 30,000.
Wait down. Why you are not uploading?
My lord, similar order may be passed. Same issue.
Where is that?
My lord, the day before yesterday it was.
No, I do not go home without uploading it.
My lord, it is not yet uploaded.
Let us see.
Oh, blessed.
Write down that number, brother. Write down that number. Why it is not uploaded?
My
Yes.
Blessed.
Next.
The petition was retired my lord in 2019.
Retired in 2019.
19.
Earlier,
And the proceeding was initiated, my lord, and the proceeding was
Lenka is saying something. You have to look at the opposite party always.
the area claims are representation annexure 5 series pending.
Arrears of?
area salary, my lords, because
Arrears of salary.
proceeding was initiated and my lords, it was dropped in 2021.
Even then they have not paid the salary.
Till date, my lord, they have not paid the area salary, increment, and regularized my service book, my lords.
They have made the representation now.
Yes, my lords.
But how that will help him? You will reject the representation. You take notice.
The punishment order has been passed by the appellate authority.
Correct.
So, the authority has to calculate and release the amount. That is it. So, your lordship may direct.
The short grievance of the petitioner is reflected in the representations at Annexure 5 series. First one. Essentially, petitioner is grieving before the court that the arrears of salary have to be calculated, computed, and released to the petitioner. First up. Next paragraph. Mr. Lenka very fairly submits that he would instruct OP number?
OP number 1, my lords.
OP number 1 to look into the grievance of the petitioner as has been aired in the subject representations in a time-bound way. First one. He caveats that all contentions have to be kept open. First one. With this proposal, counsel for the petitioner is agreeable. Next one. In the above circumstances, 8 weeks. Now, no costs. Solicit.
The product time, my lords.
Huh?
Time.
8 weeks. 6 weeks. 6. Next.
Item 8.
No costs. At the next level, cost would be imposed. Yes.
My pleasure. Now, the petitioners are the non-teaching staffs of Utkal University of Cultures, and they prayed for regularization despite 26 years of service. They have not been regularized.
Take notice.
Yes, I will take notice. I prayed for an interim direction, not to.
Is there any threat of discontinuation?
Yes, I am continuing.
Rate of discontinuation.
Any representation you have made?
No.
Nothing.
Earlier, we have approached this court. This honorable directed the Vice Chancellor to regularize.
My lords, university.
Yeah. First,
Yes, ma'am.
even you will take. They have asked Learned AG on request accepts notice for 1, OP1, emergent notice to OP number 2 and 3.
High speed post.
Learned Counsel for the petitioner draws attention of the court to the application in IA number 18852 of 2025, correct?
Yes.
Correct?
Yes.
But supported by an affidavit, wherein he apprehends that some coercive action will be taken against his clients by way of dispensing with his services or the like. First off, he submits that his clients, one petitioner? No, his clients have put in long and spotless services, and therefore they are entitled to regularization in the light of apex petition in Chago. Next paragraph. An arguable case is made out for issuance of the interim order, and therefore the OP numbers 2 and 3 are directed to continue the petitioners in service during the pendency of the petition. First off, since this is an interim order, past ex parte, it is open to said OPs to seek its vacating or variation if grounds do exist therefore. Or web copy to be acted. Original copy. Correct. Next.
Item 9.
It is appointment under rehabilitation assistance scheme, my lord.
Rehabilitation. Take notice.
My lord, thanks to after notification 4/2025, PG and PG department, J department, thereafter after document verification, my name has been serialized. Annexed 11 series, my lord.
Name appears there.
My lord. 11 series and page 38, my lord. Serial number is 124, my lord.
Now what happened?
Thereafter, another verification is 19/8/2005. Mine serial number is 5, my lord. After that verification, second phase verification, my lord. Serial. Thereafter, no engagement order has been issued, my.
Why, brother?
My lords, Annexure 14, page 47, there is a notification that rehabilitation assistance rule will not be applicable to block grant institutions.
But you have shortlisted his name.
After that, my
lords will file counter.
Issue emergent notice. So BEHERA is requested to accept notice for the OPs. First of matter lies in the Nara Compass, posted in the 3rd week of December. Okay.
Item 10.
My lord, date me.
3rd week of December.
Regarding revised scale of pay, this petitioner is a trend metric.
Covered by judgment.
Well, covered by this orders. That is annexure 5, The similar situation for
my lords, representation at annexure.
You have to consider in the light of annexure 5.
My lords, but no date, nothing is there.
You give fresh representation. Short grievance of the petitioner is reflected in an undated representation at annexure 4, which reads as under. Next paragraph. Learned Counsel for the petitioner submits that when a representation is given, whether it is dated or not, has to meet its fate at the hands of jurisdictional OPs. And this having not happened, He is knocking at the door of the court. Next paragraph. Learned AGA Mr. Behera opposes the petition unless the representation is properly presented with all particulars such as date, place, etc. It would be difficult for the state officials to consider the same. Full stop. He also submits that no proof of submission of the representation, no evidence of submitting the representation is placed on record, and therefore his clients are helpless. His official clients are helpless. First, at this stage, Mr. Counsel for the petitioner submits that he would instruct his client to present one more representation, which needs to be corrected in the light of a coordinate bench decision dated 19/7/2010 entered in WP 20224 of 2021 between Chandrasekhara
Chandrasekhar
Patri versus State of Orissa. First off, with this proposal, AGA is agreeable graciously. First, next, in the above circumstances, petition is with the above observations, the petition is disposed of. First off, if representation of the kind is filed, the same shall be considered on merits within an outer limit of 8 weeks. First, all contentions are kept open. It's open to solicit any information, etc., from the petitioner or from any other department as are required for due consideration of the subject representation. However, in that case, delay shall not be broken. No course. Next, the copy to be acted upon. In all matters of wherever we have allowed it. Yes.
Item 11.
To hold inquiry.
My lords, the private opposite party selection of who come helper was under challenge.
He seeks quashment of the appointment order.
My lord, of an opposite party number 6.
How he is concerned with that?
Yes, she was also one applicant.
One applicant. Then you take notice. Mr. Behera, you requested to accept notice for 1 to 5. Emergent notice to 6. Next.
Item 12.
Rejection order is under challenge. Item 12. Rejection order is under challenge. Similar, it is connected to items 47. 47 quota. Yes.
12 and 47.
You have the certificate due to the alerts. Earlier, another person had approached your lordship directly to continue. No, that is not that case.
47.
This is a different case. Oh, yes. This is a different case.
What is this matter about?
But the matter...
Appointment of order dated 22/5/20.
Yes.
What is that order?
Here, past services has not been taken into account for the purpose of grant of pension. But this case is virtually covered by judgment of the Honorable Apex Court in S.D. Jayaprakash. Sorry, is a difference.
A different case. AG is requested to accept notice for all of these. First off, matter lies in a narrow compass, and it appears to be covered by a decision of the Apex Court as well.
S.D. Jayaprakash.
Therefore, call the same in the 3rd week of December.
Yes.
Item 13.
Yes, Mr.
Lord, petitioner got a certificate or ST certificate from the concerned authority as per the 1980 rules and joint police force. Now he's working as DSP in the rank of sub-divisional police officer and certain canal. Lord, what happened at 95 the Madhuri Patil case came, my lord. They given detailed procedures, how detailed guidelines, how the proceedings shall cancel, grant and cancellation will be. That thereafter it was referred to larger bench, that is Dayaram versus Sudhir Batam. The larger bench decided that if there is a rule governing the field, then this judgment will not be applicable. So in our case, in our state, 1980 rule is already there. And there was a judgment of coordinate bench wherein this Honorable Court held that is as per this rule is there. So this Madhuri Patil judgment will not be applicable. But despite that, then the proceeding was initiated by the committee constituted by the government without understanding the Madhur Patil judgment. And that before the committee, my lord, I filed an application for maintenance to decide the maintainability question first. My lord, page 184, my lord, they decided. My lord, that application I categorically stated that the committee doesn't have the jurisdiction to decide them. But without deciding that issue, my lord, they are proceeding with the issue, my lord. Proceeding with now they have gone for proclamation and all that. So my humble submission that the proceeding itself is a nullity because it is contrary to the rule and also contrary to the judgments of the Hon'Ble Court and as well as the
judgment says preliminary point can be raised and it can be
preliminary point can be raised. That preliminary point, my lord, preliminary point, my lord, that is a different. Preliminary point can be raised, my lord, because now what happened in the
court said contrary to what you are saying.
No, what my ambition is that is if at least they should decide the question of maintenance. Otherwise, if my lord, they should if they decide they proceed in accordance with the
maintainability one point, merits on other point.
Yes.
CPC is not applicable.
No, my lord, what I will submit, my lord.
Better than you withdraw it. Otherwise, I have to pass the order.
They are not following the rule, my lord.
If that will be a ground in the event,
But it has got a very serious consequence, my lord. What is the serious consequence? So what I will submit that let them decide the maintainability. If it is not maintainable, then if it is maintainable, they can proceed. If the maintainability, they can proceed.
Bifurcation is not contemplated in quasi-judicial proceedings.
No.
In quasi-judicial proceeding, the question of maintainability, then on merit, is not that favored by even English decisions.
Yes.
Unless there is a rule which says in the event there is an issue as to maintainability.
No, there is no such rule. There is no such rule. But your Lordship kindly said that Lordship kindly hold it in accordance with the rule, at least in accordance with the rule they can proceed. At least that observation also help. In the meantime, there is a rule, my lord.
Social status certificate proceedings. First, the senior advocate, Mr. Mishra, appearing for the counsel for the petitioner on record, vehemently submits that the proceedings are being held in terms of decision of the apex court in Madhuri Patil versus State of Maharashtra, AR 1995, SC, page
94,
which is not permissible in as much as the Odisha government has already promulgated the rules and therefore those rules have to be followed. First off, he tells the court that a preliminary issue as to maintainability has been raised before the concerned authority. Until that is decided, the proceeding should not go further. First off, learned AGA, Mr. A.C.BEHERA, appearing for the OP, opposes the petition, contending that it is open to the petitioners to await the decision of the decision in the proceedings and come before the court or go before the appropriate authority in a normative way if and when an adverse order is passed. First, this submission accords with the general jurisprudential view in this country, since those proceedings are quasi-judicial in nature, and there is no rule to support the case of petitioner at this stage. First, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to take up all contentions before the authority, and the authority shall decide the matter after giving due opportunity of hearing to him. First, no course. Next.
Item 14.
Yeah.
Yes.
Family pension.
Family pension.
You take notice.
Yes. But may I suggest one thing? That the petitioner has made a representation to the opposite party number 3, that is the district education officer, and Annexure 5.
Petitioner is grieving before the writ court against non-consideration of his or her representation dated 19/8/2025, a copy whereof awails at Annexure 5, wherein she has sought for sanctioning and release of the family pension on the death of her husband.
Yes.
Her husband
died on 18/12/2024.
Sri Ramesh Satapathy.
Yes.
who closed his eyes once for all on
18/12/2024 due to cancer.
18/12/2024. 24?
Yes.
24. First of all. Learned counsel appearing for the petitioner draws attention of the court to the death certificate, death extract at Annexure 3. First, he submits that if the representation is directed to be considered in a time-bound way, his client will be satisfied. First, next paragraph. Mr. G, learned AGA, on request appearing for the OPs, submits that if all appropriate material is produced before the competent authority in support of the subject representation, there will be no difficulty for taking a call thereon in a normative way. If all contentions are kept open and a reasonable period is prescribed for accomplishing the task. First off, this is appreciable. Next paragraph. The above circumstances petition is disposed of, directing
OP number 3.
OP number 3, 8 weeks.
From the date of communication of the.
No, it is web posted. The whole world, it is communicated to the world at large now. I have kept everything open now because people should see what government is doing. Only for that reason. They should see what government is doing, what its officials are doing. No question of consideration. This is web hosted. You are notified. Next.
Notice is very right?
You appeared for all the OPs, na?
Yes, yes.
All the OPs.
Item 15, my lord. This is covered by Loknath Behera.
It says reluctantly bodies are not.
This is the covered by Loknath Behera case, my lord.
Serial number?
15, my lord.
50, yes.
I have already corrected the code.
You have corrected it.
Well,
give that. Mr. G, will allow this one. It's only consideration. Yes.
Number 11 of this cause list.
11?
Notice was issued.
I'm very grateful that I heard from the State Council. That your lordship
We have issued notice now.
issued.
Yes.
Deleted mean non-appearance.
No, I will not show that. Second time, when matter is posted for hearing, if you do not come, you just mark it so that we can show it in the absence. Yes.
Item 16.
Well, here my grievance is that my salary for the period from 8/1/2024 to 28/1/2024 that has not been paid. Because
about 21 days.
21 days, I took leave because of illness. And thereafter,
Let us consider your representation at Annexure 7.
Yes.
Petition prayer reads as that. Counsel for the petitioner submits that the salary for the period between 8/1/2024 to 28/1/2024 having not been paid, his client has made a representation dated 12/5/2025, a copy whereof avails at Annexure 7, and that needs to be considered. He tells the court that unless intervention is given, the same would remain on record for indefinite period of time, which would not augur well to the rule of law. First. Next paragraph. Learned DGA Mr. G, in his usual appearing for the OPs. 1 to 4.
Yes.
But 5 managing committee.
5 is the managing committee.
Managing committee has to take the decision. We will send this order to the managing committee.
Yes.
Appearing for OP numbers 1 to 5. Submits that essentially the decision has to be taken by OP number 5 managing committee.
No, my lord. By the district education officer, OP number 3.
OP number 3?
Yes.
Submits opposes.
Because I am getting grant in it.
Mr. G, appearing for the OPs, submits that he would instruct the OP number 3 to take a call on the subject representation in a time-bound way if all contentions are kept open. With this proposal, counsel for the petitioner is agreed. Next, in our circumstances, 6 weeks open to solicit. No course.
Item 17.
17 well, the petitioner is the retired headmaster of the Lagana institution. This matter is covered by
Covered by Sarath Chandra Parida.
Hemant Chotra. He lordship and issue notice in the similar matter.
Issue notice, let it come in the second week of November.
Yes.
December, no?
December.
Second week of December.
Issue emergent notice. It was on this with of notice for the OPs. Call this matter along with WP number. You one number.
Already given, madam.
Wherever we have fixed that,
Already given.
along with that it is. WP number is this. Next.
Item 18.
Yes, my lord, if petitioner has filed the application challenging the order passed by the MSMT authority, wherein my petition objecting the jurisdiction of the authority. My lord, they have said that it has the jurisdiction. MSMT authority government had itself categorically said that traders are excluded from MSMT proceeding. My lord. So that considering that, without considering that, the authority has held that it has the jurisdiction. That itself is that also, Lord Shiva, kindly see the order in front of it. Page 33, my lord.
Emergent notice. Emergent notice. Any application in what?
Yes, my lord. First day of the proceeding.
First one. Learned senior advocate Mishra appearing for the petitioner draws attention of the court to publication in IA number 19131 of 2025 and presses for interim protection. First.
That's it. I think interim order.
Yeah.
That's in the kindly have a look to page
19133, my lord. It is 19133.
page 65.
191
Beside 31.
31 na 33 191
19133, my lord.
one is dispensing with
Dispensing with.
that you cannot.
That's it.
IA number
Kindly have a look.
191 of the point seeking dispensing its production of certain copies is favored. First now, and dispensation is granted. That's not. Yes, sir.
Lordship may kindly have a look to page 65. The order dated 38/2025. Last, besides, while verifying the documents, the council found that the claimant possesses UARC bearing number so and so.
That is not
so and so prior to the
Work order.
of so and so is hence the case is maintainable. During course of hearing, both the parties expressed their willingness to settle the dispute. Given in
the
the
complexity of the matter. Complicacy of the matter.
my lord.
Thereafter, my lord, claimant is directed to adduce evidence
Yes.
against the claimant that OPs have made directly payment to SMC roadways by passing them.
This issue has not.
Appreciation of the council.
This issue they had not did not the specific issue that it doesn't have the authority in page 33, page 29, my lord. That only that he had the registration.
There is a
I'll call this matter on 11th. You come and assist. While of times. Okay?
Let's see.
Let us see. No order. No.
No, my lord, interim authority, you will proceed, my lord.
No.
You will proceed, my lord.
Because you undertook the amicable settlement
Yes.
before the other. It is there. It is there.
Settlement has failed, my lord. Thereafter, settlement has failed.
It has failed.
Settlement has failed. But that is the reason why, my lord, that is the reason why the filed the order also says that
When
settlement has failed. My
Matter
lord,
is posted for evidence when?
my lord, evidence will come on section 18, my lord.
When?
Section 18 after where the conciliation fails. Date. No, do not fix they fix a date and immediately call for the. They do not
In
fix
the
the
event
date.
you come with that, if you send the notice, you come before the court, I say that. It is open to the petitioner to move the application, memo for posting the matter. In the event, the trial begins, calling the first witness to the box. Next.
Item 19.
Much obliged.
Sure, 19. Next time.
My lord, yesterday one matter was there before my lord, that is WPC 2960025.
Similar matter.
Similar matter. That examination of staff selection commission. My lord have directed me to serve the copy. I have served the copy, Mr. Patnaik. Here also I have served. That has been posted to 14th of the November.
Notice. AG is also there.
AG is there. My lord.
AG appears for
one. OP number 1.
appears for one. The
SN Patnaik.
SN Patnaik.
For the rest of
Number 3, my lord.
He is there.
Madam, on behalf of Mr.
Patnaik is requested to accept notice for, panel counsel is requested to accept notice for OP3.
My lord,
OP3. G will appear for 1 and 2. 1 and 2. Call this matter along with WP number. Right down.
29600. I'm giving. That is on posted to 14. This is to the item 26. 29600.
Yes.
Notice ta nahi kya? Family pension hoche notice ta nahi.
Your Lordship,
So that positive order can be passed. If notice will be issued and counter comes, he will get a positive order and
it will take some.
settlement can be issued.
I think time like this.
ना time लगे वो. Pension matter short date है तो.
First, issue emergent notice. AG is requested to accept notice for all OPs. Call this matter in the second week of November, third week of November 2025. Since petitioner is grieving against non-settlement of family pension.
Item 21.
The impedency of the matter will not come in the way of considering the subject representation at an
Answer
exam.
7 series.
7 series. Okay.
Item 21.
In matters like this, Mr. G, we have, if they do not consider, next level we may consider imposing cost also.
Yes.
Non-consideration may be one of the factors to levy costs in the event petitioner succeeds in the matter. Okay. If you consider, no question of this one, matter becomes infectious. Yes.
I learned the petitioner seeking in direction to the opposition 3, regarding non-available certificate in favor of non-available certificate in respect of registration of
NAC means what?
non-availability certificate
Non-availability certificate.
in respect of
Birth of
registration of
daughter.
okay.
Where is your representation, sir?
Understood one.
Lecture 1.
Mandeshwar, the information to the registered birth and death, my lord.
What actually?
Actually, my lord, suppose, my lord, the child born in a medical, my lord, they have to inform the register, the concerned area, register birth and death, my lord.
Birth and deaths.
In case of, my lord, the child
Born in the hospital.
In the house of the parents, my lord, then he has to approach the local magistrate, my lord. And in that case,
if it is after 1 year, under section 13.
no, that will not bar, my lord. Time is not bar, my lord. They have to, the parents, in application, my lord, 3 affidavit have to be filed, my lord. One is both parents will file, and another person, my lord, is witness to the birth, my lord, he has to file. That application, local magistrate, taking into account the said information, is direct the register birth and death to register the children's.
When birth took place, which year? Which date?
Well, that is 12 January 2023. Page 8.
Well, January 23.
Lordship.
Registration of births and deaths act. Registration. Section 13. There is a due procedure.
Lordship.
Section 13. Read section 13. Do you have registration of births and deaths act with you? You take notice and tell your officer to come into preparation. All right. Yes, Mr. Dev is requested to accept notice of the office matter lies in a narrow, very narrow compass. So notice for OP numbers 1 and 3. Emergent notice to 2. First off, matter lies in a very narrow compass. First off, post the case immediately after service. Okay. Take the steps in respect of 2 and OP2.
Item 22. Item 22 related to RSAP is covered by Ashok Mahapatra case.
You copy to the
Yes,
other
I have already given the copy.
What do you say, brother?
Yes,
covered by
Lordship direction is there also. This is the order of the my lord Justice Satpathy, my lord. Lordship's order is also there.
Yes.
Item 23.
Wait, please, Lordship.
The petitioner has been continuing in the post of Urdu teacher since 2013. His case for regularization has been rejected on the ground that he does not possess the OTET qualification.
OTET qualification?
Yes, Malas. There is a test like the national eligibility test. There is a Odisha teachers training test.
State
training test. Yes, eligibility test.
Eligibility test.
Now, Malas, in 2020.
SCT under the UGC rules. State eligibility test.
Yes. Now, Malas, in 2025 August, the state government has taken a decision that for Urdu teachers, this OTET qualification,
not applicable.
It is not their fault that they have not got it. And for my juniors, they have relaxed the requirement and they have directed for regularization.
Take notice.
Grateful. Both matters are same.
Emergent notice. Mr. Ravi, learned ASC on request accepts notice for OPs, all OPs. So follow along with each other. Yes. Have you given the copy? Give a copy of the petition itself.
I'll serve extra copies. Malas, these days, Malas, the High Court directly serves a copy on the state.
Okay. Yes, by
scanned copies are directly served. Great.
Okay. Next. Item 24. Proclamation.
May I please, Your Lord?
925.
My Lord, challenging notice under proclamation, my Lord. My Lord, the fact is that, my Lord.
What is that proclamation under?
Under Odisha, the scheduled caste, scheduled tribe verification of certificate rules 2023, Your Lordship. My Lord, in the present case, what happened? The present petitioner in connection with a criminal case is inside the custody without affording any opportunity of hearing, though notice was issued to his native address and it was intimated to the SLSC that the petitioner is in custody without affording any opportunity. Proclamation has been issued, my Lord.
Custody for which offense?
For a false case under POCSO Act, my Lord. He is working as a teacher. A student has complained against him, my Lord.
Why students will falsely complain?
My Lord,
the teacher.
My Lord, there is...
Take notice. Let us.
And your Lordship in similar offences, similar cases also granted order.
No entry order. But scrupulous persons, we can grant entry order. Not usually in POCSO, accused murder cases. No, I'm not saying anything that you are innocent, not innocent, nothing. But for invoking writ jurisdiction, minimum credentials.
A boy has been alleged, my Lord. A boy has been alleged.
It is still worse.
Against the present petitioner, my Lord.
It is still worse.
I bound on your Lordship.
Let us. But notice, brother. Who? Any other? Mr. Ray is requested to accept notice for the OP. All this matter in usual course, depending upon the seniority of pending matters. Okay.
May I pray, my Lord? My Lord, no opportunity of.
Let us. It's not for people like him. Yeah, item 25.
I may be pleased, Your Lordship. I have challenged the gradation list on annexure 5, annexure 7, my Lord. The petitioner entered with the promoted to the post of level 2 cadre, my Lord, in the year 2016, my Lord. 2016.
One second. I have to write down now.
My Lord.
You have to look at the judge. That's also part of it, OPC.
My Lord.
Level 2 promotion.
Promotion to the post of level 2.
When it was given?
In the 2016, my Lord.
No date is given.
That is here, my Lord.
Give that hand.
Ortiz Bear, my Lord. 28.
Why members of the bar are not preparing the form leave? Yes, how many times I have requested him? I had first judicial order on that.
Well,
I can only request again and again. Every whole case should be in the form now. That's all. In the form it should be. If it is supplied to the judge, judge should feel very happy.
My Lord.
That is not being followed here.
My Lord. 1912-2016, my Lord. 1912-2016, my Lord.
Yes.
Taking into account date of joining in the level 2, my Lord, a provisional gradation list was issued by the authority, my Lord, government, my Lord, director, my Lord. In that...
Your serial number is what?
My serial number is, my Lord, in the gradation list, 50, my Lord.
No, you have given the representation against me.
I have given a representation, my lord. Kindly hear one thing, my lord. One provisional gradation list was published, taking into account my date of joining in the level 2 cadre by way of a promotion, my lord. Thereafter, my lord, another provisional gradation list was issued, my lord, in the year 2025, but first provisional gradation list in the year 2024, my lord.
But you will not have decided Bhishma Pratigna for not giving dates at all.
No, yes, already date is here, my lord. Yes, my lord. First gradation list, my lord. First gradation list, my lord. On 3/7/2024, my lord. 3/7/2024, taking into account date of joining in the level 2.
Then,
thereafter, my lord, for process of promotion, one CCR was sought for after 2024 gradation list is prepared, my lord. Thereafter, my lord, in that list, my name is finalized, my lord.
It's final list or
no, another gradation list was prepared, my lord.
Yeah.
In the year 2025, my lord, that is on 24/9/2025.
24/9/25.
That gradation list is prepared, my lord, taking into length of service in the level 3.
So you have given a representation.
I have given
It
representation.
should not be like this, it should be level 2.
Yes, my lord.
If that is considered, you will be happy.
You have considered till then, my lord.
Till then, nothing will happen.
No, my lord, till then, no promotion shall be given, my lord.
For your benefit, whole machinery of
More than hundreds of persons are affected in this case, my lord.
You are not holding brief for the other people. And brief for even.
I am holding more than 7 persons. I am holding the brief, my lord.
Let notice go then. Into emergent notice. Call in usual course. Okay. It will come after 5 years.
No, my lord, dispose of, my lord.
Therefore, short grievance of the petitioner is as to his ranking being wrongly shown in a particular designation which is contrary to law. First of all, the first draft gradation list was prepared on 3/7/2024 and the second was on 24/9/2025. First of all, council submits that the basic principles of formation of the gradation list have been violated and therefore he has made a representation dated.
Dated, my lord.
5/10/2025. Page 5/12/2025. 5/10/2025.
Yes.
A copy where avails at
Annexure 9.
Annexure 9.
Starting from 10 to watch 67.
First up, council submits that it has been a long settled position of service jurisprudence that when objections to the draft gradation list are filed, the gradation list cannot be finalized without looking into the same. First up, this is legally correct position. First up, next paragraph. Learned ASC on request appearing for the OP 1 and 2, notice to 3 having been dispensed with, agrees with the legal position and very fairly submits that he would instruct his official clients to look into the grievance of the petitioner as has been aired in the subject representations while finalizing the gradation list. First up, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of. The gradation list shall not be finalized without looking into the subject representation of the petitioner. Shall be finalized after looking into objections of the petitioner and other similar employees as well. First, all contentions kept to one. Okay. Applications failing to insignificance since main matter itself is disposed of.
Another matter is same, my lord.
Another is same?
Yes, madam.
In both the matters. Yes, sir.
Well, this is a case of, my lord, I am permitted, my lord. Another 4 matters are filed before the court, my lord. 45011, 45015, 45019, 45020.
Can you get them? Brother, can you get those for me so that in this order it will go?
Yes.
1250. All right. Call it 1250. Give that. You be here only and then take that.
Double piece.
Post those matters. When list comes, just mention.
Well, this is a case of transfer. Your Lordship may kindly turn to Annexure 3 at page 17. My first point is, this has been done on the recommendation of the local MLA. Your Lordship may kindly see the first paragraph.
In any matters we have.
Yes, yes. Well, my second ground is.
Well, agreeable. Still you want to argue?
No, well, there are two grounds. Your Lordship may kindly see page 18.
1A.
Well, as if the transfer order has been passed on the representation of the petitioner, no TA and DA will be allowed for the purpose.
You argued in other
Yes,
matters
yes,
also.
yes. And third is, the petitioner is an ex-cadre teacher. He is not liable to be transferred as per their policy. That is, Your Lordship.
Ex-cadre employees are not subject to transfer policy.
Your Lordship may kindly come to page 21 of transfer policy.
21.
21. It starts from page 19.
Which is the relevant part?
Relevant part is small g. Junior teachers schematic, junior teachers, assistant teacher ex-cadre and Ganashikyaks shall not be considered for transfer except on mutual ground on the ground of terminal illness of self or spouse or minor child, teachers himself and other things are there. So these are the three grounds, and Your Lordship, so far as MLA's recommendation is concerned, this order was passed by Your Lordships.
Okay.
That is the main ground, and other ancillary grounds are these grounds.
Same order.
Same order.
You accept notice, brother?
Lordship.
Three grounds are made out by the Learned Council. Appear to be first ground is being examined by us, no?
Lordship. Yes.
You appear for
all these four matters are similar.
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 Yes.
My lord, Your Lordship have been.
And same transfer order, serial numbers are different.
The same entry order. Call along with this and WP number. That WP number.
23834 of 2025.
Along with that WP and other correct.
Only serial numbers are different.
My lord, Your Lordship have been pleased to call two of my matters at 12, which are same arising out of the very same transfer.
Very same transaction.
Yes. So very same transaction, and the read petition numbers are 309.
Some of my cases have also been mentioned, and it will come.
Three will come.
Lordship, informed order of transfer, my lord. The authority considered directed to immediately relieve, my lord.
No. The order passed in allowed. That has been stayed.
Master, a teacher leaving. Where is what is that great thing? Only thing is, if other teacher has reported for duty there,
nobody has been posted to our place.
The interim orders will come to the protection of petitioner only if already known. If he or she is not already believed.
But that will they will issue the antedated order. That is our apprehension. That is our apprehension. But immediately after getting Your Lordship's order, they will issue antedated relief order. Therefore, Your Lordship passed that they may be allowed to continue with their previous place of posting.
This order is also without jurisdiction.
Yes.
Well, this order is also without jurisdiction. That I will, if Your Lordship permits, I can permit it from the transfer.
Your matter has not come at all.
Because Your Lordship is
therefore, Your Lordship taking into account, Your Lordship passed that order.
All. Quite possible. Next date we can dispose of entire all.
Batch of cases are there. Your Lordship may hear this matter.
Item 27. 27. What is this matter? Yes, issue notice. PGA for 1, 2. Yes. Item 28.
Please, Your Lordship.
Yes.
Now, that's in this case, I'm challenging the implementation of women's reservation in the junior teachers schematic.
27 is good. 27. That is a different matter.
What this matter about?
Well, this is a case where, my lord, the term of the managing committee became over on 22/5/2019. The managing committee was approved, the governing body was approved on 23/5/2016 under Annexure 4.
23, that is for a
period of 3 years. For a period of 3 years. Annexure 4 at page 24. My lord, no reconstitution was made. Then the outgoing governing body submitted a proposal before the regional director of education, who is the prescribed authority under the law. And when he did not take any action, the petitioner approached before this honorable court. Your lordship passed an order directing the regional director to take a decision. That order I have quoted of your lordships.
Then what happened?
Thereafter, my lord, your lordship may kindly see that is Annexure 5, the impugned order.
Page 25.
Page 25. The regional director of education, he says that your proposal was sent at a belated stage and you have not explained the reason for delay. These are the grounds. My lord,
let him take notice.
But notice, my lord, but another thing your lordship may kindly see, because so far as the college is concerned, it is going without any governing body for last 6 years.
Immediately will, after notice.
My lord, now what does
years have
my lord, there is a provision under rules 7(6) of the management rules of 1991. If the term of the managing committee or the governing body, as the case may be, has already been over, then the prescription will take over. The prescribed authority may allow the outgoing governing body to continue in office till reconstitution is met, or appoint a special officer to be in charge of the management during the interagram period. Well, that is there. So here, my lord, after expiry of the term of the governing body, the outgoing governing body has been continuing in its office and making all transactions. That is being accepted.
Is it allowed like that?
Well, not by a specific order, not by a specific order.
What Supreme Court said,
your lordship may kindly
where period is over.
Yes.
Similar rule in Karnataka also.
Yes.
Where the tenure of the popular body is over.
Yes.
It cannot cling on to the Supreme Court uses the word, cling on to the office. Yes. Unless specifically authorized
specific order. Yes.
Authority.
Specific order is
specific
there.
Authority. Show me.
Well, no specific order is there.
To take interest that management to some official. Yes, well, that
your lordship may kindly appreciate one thing. Well, at section 7(6), your lordship may kindly see.
Yeah.
Section 7(6) of the Orissa Education Act. 6(7).
Read.
No, 6(7). Section 7(6), I'm sorry. Section 7(6). Ticket was
134.
7(6). 134. The prescribed authority.
This is the
let me place myself. The prescribed authority may allow the governing body or the managing committee, as the case may be, whose term has expired under subsection 4 or subsection 2 of section 7(a) to continue in office till the governing body or the managing committee is reconstituted, or appoint any person or persons to exercise the powers and discharge the functions of the governing body or the managing committee during the intervening period.
Yes.
Well, my interpretation is subject to your lordship's acceptance. Well, when the term of the governing body has already been over since 2019, and this outgoing governing body, by its conduct or whatever manner, is being allowed to continue, and all transactions
by conduct it cannot. Otherwise, rule will die. Unless you cannot cling on to that position.
Then you could have immediately made an arrangement.
No, that you cannot. It cannot say. A thief cannot say, "You should have caught me immediately after you saw me." That cannot be an argument. There are such judgment. This is the illustration given.
Now, my lord,
cannot tell the police. Last week itself, you saw me in the Cuttack market and you did not arrest. Now you want to arrest. This is contrary to law.
But then, my lord, my next proposal, next submission before your lordships is, my lord, rules also provides, 91 rules also provides, suppose where no proposal has been sent in due time, that is 90 days prior to expiry of its term. then the regional director, who is the prescribed authority as per the amended rules of 2020, he is to reconstitute the managing committee immediately. Without doing that, now after 6 years, he appointed this. That
is your request for reconstituting the committee. To take a decision on that instead of discussing.
They have taken a decision. You also directed them to take a decision. You also passed on it.
Which is the decision, my lord?
Another 5 days say that your proposal is belated. All right, my proposal is belated.
That does not mean that permanently you will keep it under the.
That is only the belated. They have one of the ground, that is, my lord. And another, my lord, they have not deposited. They have deposited in account. It is not there.
Well, power is with them. Power is with them to reconstitute the managing committee if the proposal is not submitted within the time. For that reason, they cannot delay the reconstitution of the governing body and appoint a special officer after lapse of 6 years.
No, requisites are to be done for reconstituting the committee.
Well, you also may kindly see the provision. Requirement is, well, the first requirement is the outgoing governing body is to submit a proposal 90 days prior to its tenure. Well, if that is not done, then under the proviso, the prescribed authority, the regional director now, he is to reconstitute the managing committee or the governing body by his own effort. That is there. You also may kindly see the.
No, that I understand, because an educational institution cannot be run by officials. It has to be by the popular body. I can understand.
And now he has appointed the special officer by taking recourse to section 783. That is,
take notice and file objections. Emergent notice.
I have prayed for interim order, but in consensus, your actions will not pass. But so far as sub-collector is concerned, but he may not take any substantive decision. Financial.
But it's locus.
But we are the outgoing governing body.
What is your locus? Once you outgo, you go.
But your lordship may kindly appreciate. This is an unaided institution. Unaided institution.
The AC requested also for this for the OT. At this stage, no interim order can be granted.
Interim application will lie over.
Interim protection, no interim protection can be granted in terms of application in question. Since already an official is appointed to look after the management of the institution, that's important.
May please, Your Lordship.
Yes.
But I'm challenging the implementation of women's reservation, the junior teacher schematic recruitment by the government of Orissa.
Rajesh Kumar Daria.
Yes, madam. Unlike vertical reservation, where somebody who is appointed on merit.
Take emergent notice.
Yes, Your Lordships have already issued notice in similar matters.
Yes, sir.
In fact, this matter is item 50 today, madam.
Yes, 50.
Yes,
let's issue emergent notice, call along with the WP number, so 50. Let us see that what we will do.
Both matters.
Both the matters.
So item same.
Item 49.
Great.
Item 29. I am refreshing your lordship's memory. Your lordship heard that matter that CBSE matter was issued, and they were simply directed by the
notice.
Yes.
Emergent.
May I suggest one thing? I will serve a copy on Mr. Patnaik, Tara Patnaik, who appears for the CBSE. So that this matter can be decided.
Senior panel counsel, Mr. Patnaik, is requested to accept notice for the OPs. Petitioner is permitted to
1 to 3. And
addition to taking usual steps.
Yes.
Is permitted to have a copy of the petition along with all the documents on the
Lordship has passed the similar order, my lord.
An exact.
Can your lordship has passed page 33 and 34, covering the matter. There 6 and 7, 8.
When the transfer was made.
17/10/2025. They have made it. Again, I had challenged the application, but in the meantime, they have again Annexure 8, they have passed on 23. So I had to withdraw the application yesterday before your lordship, because this order has been passed Annexure 8. So by Annexure 6 and 8, they are challenged, both the annexures are challenged here, because that person, OP number 5, is working in my he has been transferred. I am on leave, Citing the notification of the government, that is
MLA committee, etc.
Yes, Annexure 9.
You continue him. I will post all those matters in the second week of November. We'll dispose of the issue emergent for this. Mr. 1D, I will request you to accept notice for 125. Emergent notice for 6. Whether Maheshwara Sahu has reported for duty?
Yes, Lord. Annexure OP number 5.
He has reported for duty.
I am on leave.
Then no interim order can be granted. It's a school.
1710 Annexure 6, my lord. That was understood.
They already.
I worked out that 1710 they are
not there. We post these matters along with the call this matter along with WP number. What is the connection matter for that?
Annexure 10, my lord.
20894 of 2025.
Yes, Lord. 20894. 25.
On the date already fixed. But if date is not fixed, then on 1311, let it come first. So that again they will take time.
1311 normally a few matters are being posted. So either it is before one day or after one day.
14, 15, 17?
Let it be 17.
17.
Let me one thing, my lord. My office has made a small mistake in page number 3.
Yeah, what is that mistake?
Serial number 1, 2, thereafter 4, 5, 6 it has been made. So 3, 4, 5.
Petitioner, counsel for the petitioner with leave of the court has rectified in a mistake
Cost title.
in the cost title.
Page number 3.
Make that.
Lord.
Okay. Perhaps you have to make the rectification in e-file also, na?
Lord.
Registry. You find that.
No, my lord, it can be here in the registry because this is not paperless.
Correct. Yeah, anyway, this order I have made. Make use of that. All right? Yes.
Item 31? 31, in this case, my lord, they have not challenged the illegal and arbitrary action of opposite party, not getting my rest part of the arrear salary 4,80,380 matter, my lord. The similar matter you will also be to dispose of my representation, my lord. Out of 14,94,226.
You rectify and give this.
Yes, one.
You rectify this. This is 4,80,380.
Yeah.
This is?
Well, out of 14,94,226. In the present case, same 4,80,380.
Same.
Same amount.
Then same order.
Same order.
Mr. Monty, is covered by
residual part has not been released in this. Yes, certificate of there is nothing called the
two matters or only one matter?
One matter, my lord.
One matter.
Yeah.
Which one we should 30270 to be printed or which matter to be printed here?
30270. 270 and
Yes.
May I please your lordship? My lord, the widow is before your lordship and file this contempt application.
Is before the court.
Yes, my lord. The contempt minor's order has not been complied with, my lord.
Not complied with?
Yes, no.
What is that order? 18,820?
Miller.
Yes, my lord. My lord, kindly see.
Order is 18/8/2025.
Correct.
The relevant page is at page 15.
Comply with this order.
This has to comply because they have acknowledged this on 4/9. Specific order was that within a period of 8 weeks, Mira. Should I?
Will you notice next day we will direct arrest?
Exactly. We can take the note of the things.
My lord, I take my lord's attention to page 17, my lord. They specifically my lords have directed.
Correct.
Yes.
But now notice, can I direct him to?
No, my lord.
Next day we will do that.
Yes, ma'am.
If they do not comply.
So breathing time because it is in the process.
The Mr. Mohan Singh requested to issue police notice to 120. Was returnable within 2 weeks. Item 33.
Can I intimate this because
it is open to the AGA, Mr. Mohan Singh, to inform to warn the OPs to comply
the order dated 18
order in question and report compliance.
So police notice may not be required.
No, police dress, if they go there.
But I will take
You will take that first. Next level, arrest and detention. It will appear in all newspapers. Then officers will be alerted. Otherwise, we pass order.
My lord, so when we are assuring something, definitely.
No, it's not the way. Always arrest and detention is the minimum thing. Because we cannot shoot them dead. At least arrest and detention court can do. Otherwise, issue first notice, second notice, third notice, second notice, 12.
No, that will not arise before this.
No use. When order is passed, they are bound to obey the order. No concession in that. Yes.
Let's here page 10 is the operative person 4.3 milliards. Your lordship order is milliards. It's annexure.
Well, here is also before that
yes.
time.
It is twofold milliard. Inadvertently, one is to be complied within outer limit of 8 weeks and cost to be paid within 4 weeks. In fact, 8 weeks have not yet. Your lordship may
to be paid within 4
weeks.
That you are entitled.
No, milliard, sir. In fact, it was to be, your lordship may pay milliards, let it come a week after, or I will withdraw with liberty to after filing.
Because time is not over.
Yes, lords. That was inadvertently.
For the petitioner seeks leave of the court to withdraw the petition.
Yes.
With liberty to approach the court again.
Yes.
In the event compliance is not.
I am grateful.
Leave granted and petition is disposed of as having been withdrawn with liberty as sought for.
Grateful. In fact, inadvertently, the past part for us. Grateful.
Item 34.
Here the petition is challenging the order annex 5. The contractual employee cannot be replaced by another contractual employee until that the post is lying vacant. That's why grant is liberty to approach the principal concern to reinstate the petition.
To make representation.
Make fresh representation.
Petition prayer
Your my lord, only I can say that it's a guest lecture for a particular period.
Correct.
So
you cannot replace one guest lecture with another set of guest lecturers.
But this is by way of a walk-in interview. So walk-in interview was advertisement was there. They may consider on its own merit. We will not stand on the own. But
make a representation.
Exactly.
The prayer of the petitioner reads. Petition prayer reads as you make it see. We would spike 3, 4, 5 and prayer. Okay. The principal petition prayers read as Learned counsel for the petitioner submits that one set of guest lecturers cannot be substituted by another. First, Mr. Mohanty resists the petition contending that where selection is made on the basis of walk-in interview, that principle is not applicable, subject to all just exceptions. First, at this stage, counsel for the petitioner supports that the petition may be disposed of with liberty to incline to make an appropriate representation to the concerned authority.
OP number 3.
OP number 3. With a direction that if such a representation is made, the same should meet its fate within 6 weeks. First, ordered accordingly, WP is disposed of.
That's not the one thing. The posting question may not be paid out.
We cannot.
That will dispose of the representation for certain period.
No. Next. Item 35.
In this IA, I have paid for a direction to regularize me in the level BA post on the date of passing of TET, which I passed during pendency of this writ petition.
22/11/24.
22/11/84. 24.
Is it not desirable that you should make an application saying that now I have passed and therefore?
Yes, I applied and moved them for 8 months after being paid. I filed.
First time it has come, or post notice matters. After notice it has come.
Writ application issued.
Already issued and counter has been filed. This is by virtue of IA.
Subsequent development of passing TET. I did.
You give copy to them. One set. We got it week after next.
Yes, sir. No, okay, nice.
36. You give one copy to
next week.
Next week holiday, na? Therefore, week after next will happen.
My Lord, item 36 may be permitted to withdraw.
Standard format. This folder. Yes. 2 minutes. I'll come back. Let's go.
Per matter that handicapped child, my lord, I pray only next week so that I can have my response to the counter, my lord.
Next week?
My lord. If it is possible, my lord.
Next week.
My lord, deeply obliged, my lord, sir.
Item 37.
May I please, Lordship? Lordship, I am appearing on behalf of Dr. Binod Kumar Mishra. On the last instance, Lordship ordered me to get the entire order sheet.
Yeah.
Although we have filed it, but we have not yet received. I have this copy that we have already filed it.
I believe you. Why I should see it? No, I don't doubt lawyers at all.
15 days time may be granted.
15 days? Okay, maybe. It's all right.
Much obliged.
That's a request, Tom.
That copy be served. It is in respect of the speedy trial. It is pending the GR case before the learned court below. That is the sum and substance of their prayer.
You direct them to dispose of stipulated period.
That is the sum and substance of the claim for that purpose. But on verifying,
I wanted to ascertain how many arguments he's claimed.
Exactly. That record is there. Whatever available record is there. In many occasions, they have filed 317. So
you have filed the exemption application 317. It is exemption for the day.
Lord, kindly see annexure number 2.
No, what is your prayer now?
That is the sum and substance.
Prayer is that a speedy trial may be done because in many of instances, the respondent of this honorable case is appellant over there, and the PWs, except of PW2, who is the informant, rest all have not been examined till the date of 2014.
2014?
Till date, only one PW has been examined.
Then we'll direct them to dispose of within an outer limit of 1 year.
That may be completed proceeding. 1 year, 1 year will be enough to go.
1 year if trial is not complete. So 6 months if trial is complete, and now pronouncement argument has to be done that way.
Much of it.
Or it will be 1 year if it has not been commenced.
That way. The defense of the petitioners is the long pendency of criminal case in GR case number 204F48 of 2014, pending on the file of learned SDJM into brackets S Katak. First, counsel for the petitioner submits that right to speedy trial is a facet of Article 21 of the Constitution of India, as observed by the Apex Court in a catalogue of decisions, and therefore the court below should be directed to try and dispose of the subject case in a time-bound way. First off. Mr. Mohanty, learned AGA appearing for?
Here, the register, I can for OP number 1, the judicial authority.
OP number?
Who is the private party? Because he is the information.
Appearing for OP number 1. On request appearing for OP number 1.
That will suffice.
In all fairness submits that since more than a decade is over, a direction as sought for may be made. First, he also cautions the court that there may be older matters whose disposal is more warranted than this. And the same be kept in view. First, there is force in this submission. Next paragraph. Having heard that and having perused the petition papers, this court is broadly in agreement with the submission made at the bar. First off, the pendency of a criminal case, long pendency of a criminal case would not augur well to the administration of criminal justice. First off, the sages of law have said that the criminal cases should be disposed of before the public memory about the crime and offender, about the offense and offenders fades away. First off. Next paragraph. In the above circumstances, learned judge of the court below is requested to try and dispose of the subject case within an outer limit of 9 months. 9 months. And report compliance to the Registrar General of this court. All contentions of the parties are kept open. Any private party is served?
Private party is OP number 2, who is the informant, because it is a quarrel between husband and wife.
Registry to send a copy. Is he represented? Not represented. Registry to send a copy of this order to OP number 2.
On fixing it to 1 year or 9 months.
9 months. 1 year.
Heavy loaded stations.
11 years are over now. Anyway, it's a
both. Because my lord has rightly pointed out that if at all any other old matters, they can seek for any extension of time.
Within 9 months.
Preferably. By that.
May I please? Despite the petitioner who is working as lecturer in English, he has been deprived of getting his monthly salary since July 2025. At this juncture, I pray that your lordship may kindly have a glance at the order dated 4/8/2025. 4/8/2025. Your lordship, sir, my lord.
This matter about now?
Matter is
any urgency.
Yes.
This is all about the change of date of birth, which has been wrongly mentioned in the HSC certificate.
Not in mentioned.
He is high end of his career.
No. High school certificate, the date of the birth has been corrected.
What is that date of?
Page 21 is 6/6/1967. Page 21, my lord.
67 appears in a high school certificate.
Yes.
Yes.
65 67. That is the
Six.
Written him what he should do. He will say me at all.
No, I will
only the year 6/6/1965,
6/6/1965,
6/6/1967.
In which record 6/6/1965 is mentioned?
Mentioned
at the end.
Entry level.
Yes.
Page?
Yeah.
No,
Annexure 3, page 18 in the board certificate.
board certificate. It is the
65.
previous board certificate. It is wrongly mentioned.
Wrongly mentioned.
Yes. And it was rectified.
We can look at some other day. Where is the urgency?
Urgency is that, but I pray that the payment should be made. I have been working with taking responsibility since July. I have not been paid. My current salary may be given at least.
He is continuing in service.
Yes, my lord. By virtue of your lordship's order.
Otherwise, when he should have retired?
Otherwise, he should have retired on the 13th June. He should have retired on 13th June 1967. 227. He should have retired on 227. June 2027.
June 2027. Otherwise, by virtue of the approval order, he should have been retired since June 2025. June 2025.
By virtue of short period, that intergurnal period, that the super the salary.
I have been prior to that. I have on 26/6/2026, the interim order has been passed. I have been allowed to continue, and I have been continuing.
That I am against. Therefore, I am telling you.
No.
Even when you may be right in saying that I have been born in a particular day. But question is, what is the date entered in the service register?
In the certificate, 67.
Which 67? No, service register.
In service register, in the approval order, there is 1967. Sorry, 65.
Approval order of
yeah. My lord,
no, 1 second. You have to hold back little slowly. Your attention. It should not be tense. When lawyer argues, it should not be tense. Gradually,
page 11.
I am asking a question to you.
Page 11, my lord.
So, if you permit me to put a question to you, I am asking you, in your service register, what is the date mentioned?
That is approval order. There is no service book in the block grant employees. In approval order, it is mentioned as 669, page 11, my lord. Page 11.
What is the
serial number 2? This is the approval order. Block grant was allowed.
What are
Service book there?
No.
For block grant employees in that college, there is no service book. Only this approval order is first order.
Where is
there is no service conditions.
Service book is not maintained. Service book has to be maintained because of their expertise.
In that college,
the intimation which has been given by my learned friend at the time, that is 65. By virtue of the same entry.
That is what I am asking you.
Exactly.
What is the entry you have given? See, that is two aspects are there. One is cases of false cases. Another is genuine cases.
Yes.
Even in genuine cases, the date of
entry
birth cannot be changed because that will be linked to the date of superannuation. Many juniors will be waiting. Therefore, Supreme Court said that's a flag end of service. No question of altering the service register so far as the dates are concerned. Even if they are few, there are at least 4 or 5 judgments which they are there in my notes now.
Dr. Yes, Anand and all other things are there, decisions are there, pattern of decisions are there.
It creates many problems to the persons who are in the queue.
No, since in my admit card for the HSC examination, the date of birth is 6/6/1970.
Why did you give a wrong date of birth?
No, I have not given any wrong date of birth.
1 second. Answer the question. When did you enter the service?
Enter on 15/7/1991.
15/7/1991. What was the date you had given to the employer?
It is 6/6/1967.
65.
67.
67 you had given?
Yes.
Oh. How many years you will be keeping quiet if that wrong?
Kindly for a moment, page 16. Page 16.
16.
Yes, ma'am. 16. This is the admit card issued by the Board of Secondary Education.
I am not on that.
But I am showing my bona fide, my lord.
You are very, very bona fide person. There is no other person who is more bona fide than your client in Cuttack. Question is not that. Question is, at the fag end of the service, you cannot seek rectification of the date of birth in the register service book because that would postpone your date of retirement, which is contrary to law. You may be true that the mother gave birth on particular date only. We don't dispute that. But question is, alteration of date of birth as entered in the service register, truth is not the only ground. Truth is not the ground.
Well, in provisional certificate issued by the board is 6667.
I am not disputing that.
The 67.
I agree.
Yes.
But why, when your date is entered as on 15/7/1994?
15/7. Yes.
All these years having slept over the matter, all of a sudden when date of retirement comes nearby, suppose if I change my date of birth, which I will not change, that's another thing. Will you tolerate me for 3 more years?
My lord, the situation is different. Peculiar in this case is that
nothing.
Previously, they were management employees. For the first time, they were allowed to enter into block grant scheme in the year 2009. This has been 17/5/10, and
I am dismissing the petition.
Yes. My lord.
Dismissing the petition.
My lord, this is a case.
Truthful case. Very truthful case. But truth is no ground for altering the date of birth entered in the service register. Can anybody assist me? Which is that judgment of the apex court? At the fag end of service, the dates of birth shall not be altered. Even if it's a wrong, it is shown to be wrong.
I have been trying. The wrong date of certificate has been.
We'll put this matter less in a narrow compass. All on 20th of November. Yes. It is always long lost when they are about to retire. Everybody will make such application. And that will create many problems. Supreme Court has said that at least in 4 or 5 cases. Yes.
Item 39. Item number 39. Lordship may kindly refer to annexure number 1, where the petitioners were initially appointed as part-time guest instructors.
Those matters asked why registry has not sent to this. Ask them to bring early. Yes. Today we have a reference. And in the afternoon I have bench also. You get bench. Yeah. Any urgency, brother?
My lord.
Any urgency?
Indeed, my lord.
What's the urgency?
My lord, the petitioners were initially appointed as
urgent.
Let me clarify what I said.
Only object is that I was continuing on time lecture. Now they have appointed.
Is there urgency in the matter?
Allowed to continue is the only.
There is an amendment petition. So far, the prior portion is concerned. It is annexure 5. It has to be corrected as annexure 3.
All right, but I will correct it and make it come.
That is your purpose.
Allow the MA interim application
in the orders,
correcting their portion and allow her to come.
Let that be allowed. Correction is there.
Application supported by affidavits in year number 19506. Some rectification in the pleadings of the petition. The amendment is not significant. And that if leave is granted, that would not alter the nature of this personal conversation. That would reflect the interpretation. First, in view of the above, application is favored and amendment as sought for is permitted to be incorporated in the pleadings. And this to be done within 2 days.
Lordship, you had filed another I as well, that is not 19507, so that no petitioners may be allowed to their continuing, no adverse actions shall be taken against them while they are continuing in their service.
They are continuing now?
My lord.
Since how long? 12 years.
12 years. Last 12 years. IA number 19507.
Not listed today.
That IA is also not there, my lord.
My lord, we have filed.
Two IA,
19507.
one IA for interim order, another IA for amendment.
139 amendment.
19507.
40 is for modification.
40 is mine.
Two applications are filed.
No, 40 is different.
As they are saying two applications, one is in the board, one
Item number 39 for Mahendra Kumar Mission.
Only one application as
that is for amendment, my lord.
My lord, we have filed two. I guess it may not reflect in the registry. My lord, I have sent, if you are not, 19507.
Not in the board, let a copy, sir.
Petitioner draws attention to another application in IA number so and so supported by affidavit, wherein he seeks interim protection, apprehending that in the absence of such protection, the services of his client may be dispensed with. First, counsel also tells the court that they have been in service since more than a decade, and therefore, the job being the only source of livelihood, the same needs to be protected. First, there is a prima facie, there are prima facie elements for consideration. First. Next paragraph. In the above circumstances, application having been favored should be directed.
Director. The director. Opposite director, the opposite party number, opposite part number 2.
OP number 2 is directed to continue the petitioners in service with the same addition during the pendency of the petition.
Let that two IA be served, my lord.
Give copy.
My lord, we have given. We again give the.
His name may be recorded, man. His name may be recorded. His name may be recorded, man.
Yes, sir.
He is interested to close the matter, therefore.
Third, see, sides.
So that.
The order of transfer, my lord, similar to item 26.
Similar to
item 26, MLA ground, my lord, ex-cadre, petitioner is ex-cadre, MLA, and a widow mother-in-law who is suffering, my lord, he is the only person to taking care of.
No children to the mother-in-law?
No, children are working in a different place and transferring 150 kilometers, and the transport communication 3 to 3.5 hours to go and 3 hours to.
Your client is here.
No.
Nowadays they are all in VC.
Seeing,
I have corrected.
Corrected.
I have fixed to 17th November. Similar all matter.
Yes. 41.
Made please.
Yes.
There's an interim application for amendment that is IA number 651 of 2020.
The amendment, brother.
Well, it's pursuant to the filing of the writ petition. There is one of the ground that the authority who has passed an order is not the competent authority. There was one of the grounds.
One of the grounds.
Well, it's other grounds.
No. You should say one of the grounds.
One of the grounds. I beg. My lords. One of the grounds. Reply counter affidavit has been filed. In the counter affidavit, they are relying on a office memorandum issued by the Union of India, which gives them.
Come up the few days.
It's not management.
Call up the.
Plus, there's an interim order.
Interim order?
Yes.
Other side is not here.
The state, Malats.
State?
Yes.
But a copy has not been served.
You give copies.
IA has been served, Malats, on 10th of January. It has been served.
No interim order.
Interim order is there too.
There?
Yes.
In all these matters.
Well, that's 41.
It is 40. Okay. For amendment.
Health. Yes.
Interim order to consider. I have got this. Okay.
Obliged.
Small. Item 42? 42.
Declaration matter. Structural comment some of them.
But no, this is a similar matter, also covered matter.
My lord, 2 items, it has 4 sub-items. 2 sub-items are covered under the judgment passed by lords.
Which are covered?
My lord, WPC number 18886.
Give to Brother Linka.
Yes.
Which are those covered matters?
Under little. My lord, sub-item 1 and 2 of 42. 18886 of 2024 and 18891 of 2024. I've covered, my lord.
Four cases are covered matter, but the appointment date is different. Last 2 persons have appointed on 2017, but the first 2 persons have appointed
on 2013, and all others are similar. All the issues have been decided in the little point case.
Yeah. Yes, Mr. Lenka, all they are covered by the judgment.
Let them have a copy.
Give copy.
Yes, ma'am.
My lord, the as per my instruction.
Give copy.
No copies, ma'am. Good.
One copy for me.
Yes, sir.
Correction has not been.
Also, the subsequently passed will go.
That Jago Shripad.
Covered by judgment. No.
Yes, sir.
All are data entry operators.
The subject matter of all these petitions is substantially similar to the ones in WPC 19084 of 2023, etc. between Mithun Pradhan versus state and others, heard and disposed of by this court by judgment dated 17/9/2025 in the light of Apex Court decision in Jago versus UOI 2024 INAC 1034. First, in the said case, in the cognate case, the impugned, the order impugned, in the cognate case, the following relief has been accorded to the litigants therein. Operative portion. Let's say this, in the cognate case, the following observations occur. First, it has been a settled position of law that similar cases should be treated similarly in the light of mandate enacted in Article 14 of the Constitution. Here. First, next part, in the above circumstances, these petitions are disposed of, granting same relief as has been granted in the cognate case, with the cognate case, mutatis. The dates alter there. Dates. Yes.
Article 43. My lord, item 43 can it be taken up any day next week, lords?
Next week, difficult week of next we'll have that.
My lord, may I
On behalf of Mr. Mahapatra,
regulation matter 26 years of service. My lord, I am squarely covered by your lordship's judgment of Orissa water supply sewage board.
Division bench, myself and South.
Yes, my lord. Then Shripad, Jago and Dharam Singh.
Senior would assist the court, lords. Any day next week.
What's the time?
Yes.
Call this matter of 1911. Since it is submitted by the counsel for the petitioner that the case is covered by the division bench judgment of this court in which it is that.
My lord, Orissa sewage board.
Right, so thanks.
And Shripad, Jago and Dharam Singh.
We have referred to those judgments.
Yes, my lord. Yes, my lord.
In this case. Okay. Next.
Gratefully.
Item 44.
Yes. But there are two connected matters. So far as item 44, first item is concerned, Mr. Sangram Jana is appearing. He requested me to do this matter.
Even otherwise, I will permit you to argue.
Yes. But this is a case where, my lord, the level 5 ex-cadre teachers.
Can we have it in the third week of November? Yes, third week of November. Yes.
Item 45.
You can say suo motu adjourned to third week of November. Yes. Yes.
This is a claim of pension and pending dues of her husband, my lord, and who was working as a primary school teacher, mentally retarded, my lord. And as per NHR 1, my lord, his regular service 2595. And as per
You want hold it to me. I will hold it. Third week of November. Yes.
also counter also filed, my lord.
Yes. Next.
Item 46.
45, no? 45 again.
May please, your lordship.
My lord, pass over this.
Not possible. Today, not possible. Today,
engage in other courts.
Yeah. We'll have it in the second week of third week of November.
Second week of November, interim orders to continue, my lords.
If interim order is there, we'll have it in second week of December. Interim order is there, protection.
My lords, they have violated it and they've gone to confirm it. That was their submission on another day in a different matter. That is why I pray your lordship may have it in the third week of November. Also, we are okay, my lords.
On 18/11. Interim order to continue.
Grateful, your lordship.
Item 47. Item 48.
48.
47 to exam.
Yes, brother.
Filing application for intervention. Copy, yes, my copy. I am the petitioner, my lord. Copy was served on me on 28th, my lord.
No, my
lord. 7 days for objection, my lord.
Not served.
On the same day, earlier day, I am sent on through WhatsApp. And hard copy on.
Hard copy on 28th. I received hard copy 28th, my lord. 7 day time frame, 7 day time for filing objection.
30, 12/11? Yes. 12/11, all right. Any urgency?
Urgency.
No urgency.
This is a joint family property. My husband died. He had two brothers. He is the elder. So after my husband died, my lord, he has come. I have a small one-story building. There is no partition made and bounds. And he raised a high-rise building that is G+3. G+3 and shadowing my entire property. And I am unable to live there. The entire thing is shadowed. And it is the, how many times we have come to the Central Court, then it is remanded, thereafter appeal after appeal. This case is also not maintainable because I have filed a short note.
Today I have no time because of reference, etc.
That's a
full court meeting.
Short time fixed.
On 17/11? Earlier.
12 till 11, my lord said.
12.
I'm serving a counter affidavit also in course of the day. I am handing over to my friend the counter affidavit.
To his application.
Counter to his
petition.
Yes.
That is 33 matters. Sir, 1 second. Many 33 matters are pushed on that day. Your matter may not reach it also.
Okay.
Therefore, 13 which day they need it?
It's 21st.
Yes, on 21st to be taken. Interim order to continue only till 21. Till next date of case. Yeah.
Item 49, 49 and 50 has been adjourned. Item 51.
51. Petitioner. You are called petitioner.
My lord.
Implement the judgment of this court.
My lord.
Is it contempt matter? No.
No, my lord.
Earlier, my lord, so there is order, my lord. Last occasion, my lordship directed the Lord AG, my lord, to take option.
Yes, brother, there is a judgment to implement another case to be filed. And that judgment, implement that another case. It will be endless.
I pray, my lord, so that your lordship may
dispose of this matter directly in the OP number 4.
No, again, that will be the same thing. They will not implement. Then one more case you have to bring here. It will be endless. Why, brother, why are you not implementing who has to implement?
OP number 4 minutes.
Keep OP number 4 present before the court on the next date of hearing.
Lordship, kindly answer to page 40, my lord, annexure 9.
41.
40, my lord, 140. Annexure 9, my lord, he was requested by the concerned authority, my lord, to present before him and along with other documents, my lord.
No, you keep him present. It's a pension, na?
My lord.
They keep that OP number 4 present before the court. Something has to be done to these people. OP number 4 is requested to be present before the court on 11/11/2025 to explain as to why the judgment dated 27/5/22.
My lord.
Right?
My lord.
There was contempt also. There was contempt matter also. There you have taken time. Instead of requested, it is directed to be personally present before the court. On 2011. However, personal presence shall not be needed if in the meanwhile the judgment in question is implemented. Yeah. List is there? Over.
My lord,
Other matters, 13 matters. Ask them to bring.
my lord, may I?
That's what. Yes, I will. After they are ready, call me, I'll come back. They have to sign many papers, na?
May I just submit?
Let the copy.
I'm not on that. Item 40. One thing since I inadvertently did not submit, my lord, in item 40. Item 40, I filed an application for modification. So that may be taken note of. Because my lord have already passed an order.
What is the modification here?
Previous, my lord, though notice was issued, but no interim order was passed because though interim order was dictated, but inadvertently that was not mentioned. I have given the similar order, my lord, today.
Counsel for the petition.
Only IA to be reflected.
And there is no reason that though the interim order was granted on the earlier date of hearing, the same has not been printed. And therefore, the court in exercise of its power ex debito justitiae has to grant the interim order.
I have given the similar
first. He has also placed a format of the order made in other matters.
I have given my lord. Corrected copy there is.
Registry to print the interim order. Interim order, as was stated in the open court. You have to print that, na? Why it happened like?
No, my lord, I have given the corrected copy just when matter was called.
Print the we'll say print the section in terms of that we shall.
No, my lord, same order, item 26 also similar, that transfer.
26 also not printed.
No, 26, along with 26 that will come, my lord.
This will come along this. Call this matter along with serial number 26. Okay? In the second week of December.
No, my lord, 17. That transfer.
Fixed already?
My lord, mail transfer.
Along with other matters.
On 17th of November.
After the case papers come back, just call it a program.
in this civil division, it's a reference by the Honorable Single Judge to this Honorable Court for answering 2 questions under Order 21 of the CPC.
21 rule?
Rule 11 to 17, there is part of execution, whether an amendment can be made to the execution petition or not after 12 years. So, for actual background, I may state, there was a suit at the Calcutta High Court in the original jurisdiction. It was a money suit. The suit was decreed. Thereafter, execution was levied before the Honorable Calcutta High Court also. Before the Calcutta High Court, the property was inserted in the execution petition to be attached, which is situated in the district of Bhadrakat, Orissa. So thereafter, the Honorable Calcutta High Court transferred the matter, the entire execution case, to the Bhadrak Court at Civil Judge Senior Division Bhadrak to be executed at that. At that point of time, it was learned by the decree holder, who is the petitioner in this revision also, that the property which was included in the execution or being attached, that has been sold by the judgment debtors.
That was sold on which date? Before the filing of
that is exactly
after the decree.
No, that is exactly not clear from this order also.
Necessary.
Is that
unless that is fixed, the rest of the things will pale into insignificance.
So that is, I also exactly wanted to know that date, but that is not available.
At least
either in the reference order or in the impugned order also. It's not specific.
You have to say. You are for the
petitioner.
Execution
decree holder, yes.
Decree holder.
Yes.
You have to say that.
So that is exactly not clear.
There is a provision under Order 21 Rule 16 in case of any transfer of the property.
Set aside, like
involved in the assignee to be a party there.
But that depends upon the fact as to whether the property was sold during the execution or prior to that.
That is essential.
So that is, yes, I know. I am conscious of that. But that I was finding out from the impugned order also. Challenge in the civil division. That fact is also not clear, very much clear.
No, you have to say that.
So,
if you want interference of this court, because Order 21 Rule 16, there are judgments which say has to be read with Section 52 of Transfer of Property Act.
Yes. Lispendence. Lispendence. Is that in the
to fix the idea of lispendence, to invoke that, then when that transfer took place.
So
if
that
it is transferred during the list, then pendants will apply. Otherwise, it will not be applicable.
In the present case, what happened?
No argument will be held. Unless you tell the date on which the alienation. There is Justice Rajamannar, Madras High Court Justice Rajamannar's judgment, which has held under the old CPC, before pre-1976
76 amendment.
They have held that way. I don't remember. I think it is Chokkalingam versus something like that. I don't exactly remember. Years ago, I had read that.
You are too interested to include the assignage.
No, the holders, they amended the execution petition, inserting 2 more properties. That was objected. So
beyond the decree.
No, that was not in the decree. The decree is only for money. It was only for money. So in the petition, 2 plots were given. By way of amendment, another 2 plots have to be included. So their objection was raised that because by the time of the inclusion, 12 years have already passed, therefore it was not maintainable.
12 years are already passed, means that his execution is already levied.
Execution levied, but the learned trial court comes to a conclusion. The date of the amendment, 12 years have passed.
May not be correct.
So that is.
You are wanting to recover the money?
Yes, exactly. Yes, attachment, supplying immovable property in place of another property, that is not connected with the filing of the execution.
At all.
So that is the moot question in the present case. Now,
no notice was issued to the other side.
No, it was noticed. It was hard, but Honorable kindly have a glance at this reference order. It may not be also very reference order was passed on 23/6/2003. 23/6/2003, about 22 years back.
2003, such a small matter which would take 5 minutes. Suppose if the decree were to relate to, if the decree were to comprise or affect the immovable property, then what they would have said is
It's a simple money decree.
money decree.
Your money decree.
You are changing some property.
Yes.
How limitation question will arise in changing that?
Yes, that is exactly.
It is a mode of recovery.
That's
Mode of recovery only.
Mode of recovery.
Even I don't put any property in the execution petition or say, separately, I can give it. No problem. But that was the.
Not but perhaps the learned judge has misconstrued all consequences of the case.
Now what has happened in the reference order, the Honorable Single Judge, he confronted one judgment of this Honorable Court reported in the 1990 CLT, saying that amendment is not permissible after 12
Where
years.
is the amendment?
That is exactly the question, and now that has been reported whether that is correct or not.
The appendix, which has been given under order 21 rule 11.
Yes.
Arrest and detention attached.
That is the only question, nothing more.
That's all. Who appears for the other side?
I don't know, it's 22 years back.
The name is there, man.
Please go. No, if lawyer the part is
The name of Mr. Prahlad Kaur, of course, is now P. Kaur is there. I don't know the Wakalat now. I think it can be.
I'm not as good as you are. Brother Justice Behera is known for his expertise in civil matters.
Yes, I know that.
In Rustumji's law of limitation, identical case is discussed. Rustumji on law of limitation, there is one standard book. Of course, many books are there. In one book, I read identical, I remember, vaguely remember. It appears it's the Madras High Court Justice Rajavanna's judgment, a great judge of Madras High Court. Chokkalingam, something like that. I vaguely remember the name. But I very vividly remember this is the limitation question in a money suit will arise at the time of decree in execution. They call it levying execution. In South India, we call it while levying execution. If the petition is filed, over.
Limitation.
After what all the executing court will do to ensure the compliance with the decree.
That has no connection with the filing.
Mode of execution, which my brother has.
It has no connection with the date of filing of the execution.
Nothing to do.
So this has to be answered only, nothing more.
But to answer that also, we need to hear the other side.
And that is exactly.
This is given to the state court for the madam comes petitioner present. The name of Lana and the SP Cora is given indicated in the counsel for the opposite party. But
it is only P Cor. It is only P Cor, not SP.
Lana counsel P Cor, na counsel P Cor has expired since long ago. In the meantime.
It is expired. He has expired.
A notice from the side of the court is required to be issued to the opposite party because the presence of the opposite party is necessary for the just hearing of the revision in his presence. There is directed to issue notice to the opposite party indicating whether
indicating date of hearing.
Indicating the date of hearing.
That's also difficult to come. This is an accidental bench. We do not know when we'll sit.
The revision will be listed.
Any date it is suitable.
No, since this is an accidental.
Yes, yes, definitely.
We do not know when again we will be meeting.
Before this bench.
Next sitting.
In the next sitting. On the next sitting.
On the next sitting.
Yes.
Yes, sir.
Next.
Yes, sir.
When the bench will be released.
Yeah. So you bring some rulings. There are always, this is not a new case. CPC is as old as 1862, 1908, then 1976. Therefore, many judgments. In Madras Law Journal, Madras Law Journal has published 4 volumes of CPC. In 1 volume, you will find the answer. And in Rustumji's Law of Limitation also. Yes. Correct.
Replacing one property, another property.
I may plead your lordship.
So
matter relating to livelihood and the regularization of the services of a typist. This is a matter relating to regulation or livelihood of a typist.
Yeah.
Who was appointed under the family judge Khordha Bhubaneswar at Bhubaneswar. But if a lordship will look at the writ application, all the materials will available on record that the government created the post in the year 2011. Under family judge, let's say kindly turn for the lordship's convenience, I may bring the lordship's attention towards page 9 onwards.
The question is, 2008 rules are applicable to you?
No.
Not applicable.
What I'm trying to converse your lordship is that now I have argument twofold. I'm advancing my argument, but I'm twofold. First submission is, since the family judge was declared as a separate cadre, it forms a separate unit and family judge the competent authority to give appointment. Accordingly,
we have rejected this condition. That bench rejected.
That was called, being not influenced by that, lordship kindly consider. That I have not read the judgment. Consciously, I have not read the judgment.
Myself and house.
That's true. That was the case because I'm before lordship. I felt guilty on that date when I filed the application to recall. It was my mistake. I could not bring to lordship notice. Lordship, look at the new and my second argument. But I forget on those days lordship deprecated or negatived. My humble submission is second form of argument is that I have appointed to an open market by the family judge, who is also senior judge, division judge. And
who is the appointing authority under the 2000?
The state say the district judge. I was appointed by the family judge. I've completed 7 years.
It appears there is a committee.
There is a committee,
There is a committee.
as it has been provided under Rule 6. Under Rule 6. Constitution of committee is there.
He is incompetent to make appointment. If he
is by the district and system.
My humble submission, therefore I'm advancing, like the present, the affirmation of the apex court in the same line. Even constitution of the Uma Devi, what they said, that all the persons for public post are supposed to participate. That is Uma Devi in line with my humble submission for Lord. The entire constitution, Supreme Court, Uma Devi constitution has been said, the basic structure of Article 1416 has to be maintained, and thereby all the eligible persons for the post in question should be allowed to appear in the test. So deviation thereto is illegal, irregular, and illegal has been defined also.
That's right.
I say even if my appointment is irregular,
not illegal.
Irregular. I say illegal. Like saying illegal. I say irregular. Years, wrong. I mean 24 years, wrong. And appointed by a competent authority, I should be considered for regulation. That's all. That much I can advance my argument. I've already submitted my note. I've given the judgments. But the entire contention is my appointment is fair. No malafide is attached. I have appointed through public advertisement, compete with others. Now the dispute between district judge and family judge, I should not suffer. That's all. And then entire contention, district judge the competent authority. Therefore, family judge has no jurisdiction. I have given certain documents, trying my best to advance your lordship that he has the authority because he was treated as a different head of office in terms of the statute and governing the field, super service code and other things. They are also government employees.
Do you have the division bench we held?
Yes, ma'am.
Appointment. Do you have that judgment? Do you think that? Yes.
Sorry, my lord, I have one question.
That judgment where we held, the appointing authority is not the family court judge, but it is the committee.
My lord, in this case, Mano.
In this case only.
That's true. That's what I'm saying. Something influenced by Lordship. This is not Lordship. Replace nine well. That is why I'm not review.
Exactly.
Not
review, in fact.
Some judge thinks that Justice Sahu was the case. He was filed a counter. Everything. Government of Lordship kind notice. Therefore, try and again and proceeding Lordship. Don't be being influenced by that order. I have not read the judgment. Confess your Lordship, my lord.
Renuman district judge, my lord, that is the landmark.
The entire constitution is complete. Today, bona fide appointed, compete with others, considered my lord for a contractual appointee, no adverse remarks. Even I am told that I am complete allowed to non-official put 20 votes. I am not terminated. And my appointment was kept in my hands.
You are arguing, but you are not taking the court with you.
I am sorry, my lord, what I can do? I mean,
no. Question is not merits. Question is the communication skill. Communications.
Maybe, madam. You are not
speaking our mind at all. You are not entering.
Maybe, madam.
Mind at all.
Maybe, madam. I may not be able to carry your lordship, madam. That's maybe communication inability.
What for it has come now?
The entire order is recalled without being entered into the decision rendered by your Lord's division bench. Because one of the honorable single judge was a party to the case, therefore it was recalled. Lordship is not recalling that truth.
That quorum.
Recalling all right, but reasoning remains correct.
That I recalling up to your Lordship, my lord. No. I simply said my second argument I'm advancing. Since I failed in first one, I'm advancing. I've completed 7 years through this come. Therefore, I will have to consider. That's all.
Your give dictation. You articulate your point.
My first submission for Lordship is
right now. Slowly.
My first submission that the petitioner was duly appointed through an open market and he was through a competition. He was selected by the family judge. Khordha Bhubaneswar. And as per the government decision, the family judge Khordha Bhubaneswar was declared as the head of office. Once someone is declared as head of office, the cadre.
He has to write down.
I'm sorry.
You are giving dictation. Yeah.
The family judge Khordha forms a separate cadre, and cadre means the strength of service or which forms a unit. Therefore, once an office is declared as a head of office, the same should be, the employees of the said office should be from the separate cadre and the head office should be the appointing authority. Even considering for the sake of argument that the state has taken a plea that the district judge is the competent authority and rules governing the field for appointment of the said rule. And since the said rule has not applied in the present case, the appointment of the petitioner is illegal. My humble submission would be at this stage that even considering for the sake of argument that is there, my appointment is not irregular. It may be illegal, it is not irregular. I have completed, my services was kept in advance. I had completed 7 years of service. Therefore, let the court consider my case, humbly submission, consider my case insofar as it is a form of Article 20 of which is form of Article 2 livelihood. That's all, my lord.
Heard. Dismissed. Yeah.
I have note also. Highly obliged.
Is it?
Same date. Yes, my lord. Date is my lord 23rd, 10 and 24/10.
Relieved or not?
No, my lord. All this same order as that.
Is he relieved?
No, he's on leave. Yes. Same at running page item number 26. This is the order your lordship have passed.
Lordship get a see the input order, sir, para 2, my lord. So para 2, I have now holding the brief, my lord. Para 2 is the immediate relief order, my lord.
Yes, that is
not leave, my lord.
If not relieved. But Swain says, no, Mr. Swain says, if you write that now, they will create some document.
They will issue antedated order, antedated relief order.
You can make it clear. If suppose we will state now, you move an application. If they are already relieved, you move application. As on the date you pass the order, they were already relieved. They are reported for duty.
My lord, may kindly say one thing.
You are spoiling your case.
No.
You are spoiling. The lawyer should know where to stop. First principle of advocacy. A lawyer should know where to stop. Where to put forward. The famous book, 7 Lamps of Advocacy by Chandrasekhara Iyer. In 1930s it was written. It's a great advocate in Madras High Court. We were very good. I have seen him. But I should tell it to you also. Yes, brother, suppose if I say that sentence, they are right in telling that you will put some record and you will say, yesterday only you was relieved. It has happened in some cases in Karnataka. Yes. If there is such a thing, you file application, we will hear you. That's all.
School cannot run, my lord, without a teacher, my lord.
No, whichever teacher is there. With them you run.
If you will continue and leave, my lord, since 1310, my lord.
Court has directed the petitioner to be allowed. The petitioner to be allowed to continue in the very same place.
Previous place.
Your
Nobody is posted.
Your lordship sees your lordship's order.
Issue
Same order.
Emergent notice.
Same order.
You requested to accept notice for. I have wasting time of my book. For the OPs, block it, all OPs.
Yes.
All OPs. First time. The Net Counsel for the petitioner draws attention of the court. IA number so and so of 2025, wherein interim protection has been accorded by a sort form. The transfer order. First time. The Net Counsel tells that in a series of cases, interim protection has been afforded to the similarly litigants, and therefore such a protection cannot be denied to his clients. First, there is force. There is prima facie force in these submissions. Next one, learned ASC appearing for the OPs vehemently opposes the application, saying that without school, without teachers, schools cannot run, and that would put the students to untold hardship. And therefore, no interim protection be afforded. First off, this is difficult to countenance because already similar protection has been afforded to all similarly circumstanced litigants. As already mentioned, above. First off, it has been a rule of adjudication since centuries that a relief granted to a set of litigants cannot be denied to other similarly circumstanced set. No just exceptions. First off. Anyway, matter is being heard on very shortly along with other connected matters.
It has been fixed to 17 November.
17/11.
Along with the WPC number.
And the heavens will not fall down if interim order is granted. First off. Next, in the above circumstances, issue interim order as has been issued in WPC number
23834 of 2025.
23834
of 25.
First of all, call this matter along with WPC. All these matters same order.
Yes, yes. My second matter is mine. That is said.
In item 2.
Two is open.
Yes. Item 2, this is also a case of transfer. Here, my lord.
Or any different?
No, not same, but it's similar, but in the order it has not been reflected.
Means?
But so far as other cases are concerned, in the order it has been reflected that on the recommendation of the MLA and it not. Here it has not been reflected, but
it appears that it is made on that.
Also. Yes, and second ground is ex cadre.
Then same order. One more point. In addition to that one point we can add.
You also may indicate that, otherwise I will be misunderstood.
Counsel for the petitioner very clearly submits that the MLA ground is not conspicuous from the order text of the impugned order.
Yes.
Come on. But that element exists. First, he further submits that the extent of transfer guidelines exclude the ex-cadre teachers.
Yes.
Either. First.
And this order is also without jurisdiction.
Lastly, he submits that order is without jurisdiction.
Your Lordship may kindly come to
all these
page 27. Yes.
All these aspects merit deeper consideration at the hands of this court when other connected matters are also taken up for the area. First. Next. Okay.
All other matters are similar.
Separate.
In the order, it has not been reflected.
Item 3. Item 3, I am challenging the order by the annexure 23/10/2024. While Krishna working as a principal in charge, he was transferred on the ground of administrative ground.
When?
On 23/10/2024.
Administrative ground.
Administrative ground by pressure of the minister. It is mentioned. Copy forwarded to the PS to Honorable Minister Higher Education. That is, within the same order, they have transferred from Kotak to Aska, which is 300 kilometers. In the same order, they have mentioned, since the petitioner reader in mathematics has been administrative ground, he may not be assigned the charge of principal till his retirement. One is transfer, second is punishment, not to give promotion. Then third, in the same order, they have directed to the sub-collector to, in page 31, the president of the committee with a request to relieve the teacher under the order of transfer immediately and punish the review such as review. Further, it is requested to initiate a major disciplinary proceeding against the petitioner. And
Why I want to give relief, you want to spoil it?
No,
I want to give relief to you. If you want to spoil, argue further. No. What kind of advocacy? What kind of foreign was? I wonder the locality of the bar in advocacy skills. No research, nothing, no language, no communication skills. I'm very sorry to say.
I'm also.
What kind of advocacy? I do not know why your clients have not filed cases against you. Issue emergent notice. Learned A.C. requested WhatsApp notice for the OPs. Learned counsel for the petitioner draws attention of the court to the application for interim protection. First of all, he contends that firstly, the transfer order is marred by Mullah Friday because there was interference of the minister concerned. Secondly, he submits that the he urges other grounds also. First, the apex court in Shilpi Bose versus Swine so held that Mullah Friday vitiates the transfer order. First, this in more or less similar cases, this court has already afforded interim protection to the two employees of the kind, and therefore the same needs to be extended to petitioner as well. First, next paragraph. In the above circumstances, the impugned order is stayed till the next date of hearing. First of all, the OP number, who has to continue you?
Nobody is coming. I'm continuing till that. I'm not.
Who has to continue? To whom I should give direction?
The OP number 2.
OP number
1 and 2. Secretary and director.
OPs are directed to continue the services of petitioner at the same place in which he or she was working immediately before the issue of improved order.
So may I, Lordship, may I
the petitioner instance.
May I submit one thing? Lordship, I remember this matter one lecturer, lady employee, sexual harassment case. Lordship, that double piece is referred in page 40. That will be better.
Brother, I will, along with that matter, we will take.
Yes. I am ready to go to the nearby place because after 6 months I returned from service.
You have said that twice now. I am asking you, if you want a transfer, why court should stay the transfer now?
No, they have
other things I can understand. Disciplinary inquiry, such other things.
That the transfer is part by virtue of the repressor.
Correct.
Yes. But and they have also given direction not to give promotion till retirement.
That will stay. That order will stay.
Yes.
But transfer you will consider separately.
Now they have filed to relieve the petitioner. Once they have already withdrawn their relief order.
No, you want to go. You only said that he is not
I go to some nearby place. It is they have transferred to Punjab.
Brother, you consider his case for a request for posting him to some other place.
Yes, till then stay. It will come to 1 week after. Because they will be directed for relief.
No, stay. But I will tell them to give some other place.
Yes,
but rest of the things.
The nearby place they will be transferred by God.
Nothing will happen if you are not heard learned counsel, heard learned counsel for the petitioner. First time. Is a petitioner is going to retire within
in the month of June 2026.
In the month of June 2026. And thus a short stint of service period is remaining. First off, further he tells the court that he will not object to the transfer to any other nearby place. First, next paragraph. Learned A.C. vehemently opposes the application, contending that when a person is involved in heard learned counsel for the party, then he will peruse the petition paper. This court is of a considered opinion that the punitive action contemplated in the impugned order has to be kept in suspended animation. First, this apart, petitioner can be shifted to a nearby place than the place indicated in respect of which a decision has to be taken by OP number 2. OP number 2. On a what first one. Next is the opposite circumstances.
Lord, I may be pardoned. Lord, in item number 2, accepting first matter, so far as excluded ground is concerned, in other cases that ground is not there.
No, I am giving dictation. Kindly wait.
In the first case, my lord, that is there.
Giving dictation in this case.
Yes, I'm sorry.
In the above circumstances, the order is stayed to the extent it contemplates punitive action against the petitioner, and also denial of consideration of his case for promotion. First, however, so far as the transfer is concerned, as already observed, the OPs, jurisdictional OPs shall give posting to the petitioner in some other place nearby, some other nearby place immediately.
Yes.
Immediately. Okay.
He
wanted to say that one, na?
In the first matter, excluded ground is there. So far as
then excluded will remove. Then excluded will remove.
Other grounds are there.
Other things. You can argue that matters. Yes. Your excluded will that ground to be excluded. Yes.
Item 5 is a different matter. Let it come in the regular.
My lord, item 5 is item 4, my lord.
Item 4.
Item 4. I am challenging the transfer order under annexure 5 on the ground of my this is violation in
Yes,
my lord. The petitioner challenges the transfer order dated 25th October 2005, annexure 5, my lord, on the ground of
slowly.
My lord.
Yeah. Transfer order is dated
25th October 2025, page 15, annexure 5, my lord.
How many kilometers?
50 kilometers, my lord. That is in violation of government instruction dated 5595-94. That is under annexure 6, my lord. Page 16. I would like to invite your lordships. Page 17, para 2, clause 3. Officers who are my lord. Sorry.
Page 16.
Page 17, my lord. I am referring.
17.
Para 2, clause 3. Roman 3, my lord. Officers who are going to retire within 2 years would be allowed to stay where they are. My lord, the petitioner is going to retire.
Subject to exceptions contained in para 2(3) and 4 of the General Administrative Department Circular number 5. So, notice for the notice stay of impugned order till next date of the.
Till that decision, I will not disturb. Till that disturb. New transposition, new class of.
Item 5.
Take up next week, my lord. Along with my lord, WBC number 153.
So there is a reference going on.
Next week, only next week, only next week, my lord.
Also,
Item 6.
cannot.
Item 6, well.